You sued two doctors claiming that both were careless and caused you significant harm and injury. And now, what is the likelihood that when I question each of these doctors in a pretrial process known as a deposition, lawyers also call it an examination before trial, that I will be able to get one doctor to actually go ahead and point a finger at the second or third doctor whom you have sued? Would you like to learn the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer to my question is, in all likelihood, 0. That is the likelihood that I'm going to get doctor number 1 to point a finger at doctor number 2 or doctor number 3. In all likelihood, my chances of getting the doctor to do that are 0. Why? One of the most common defense strategies in these medical malpractice cases is don't point fingers at each other. That's the defense. Why? Because they know if doctor number 1 points a finger at doctor number 2 or doctor number 3, now doctor number 2 is going to turn around and point a finger at doctor number 1. Oh, I didn't do anything wrong. You did something wrong. Well, I didn't do anything wrong, but if this patient suffered injury, it must have been doctor number 3. Now, what does that mean? It means that we don't have to do much as the plaintiff, as the injured patient. We can basically sit back and watch the defendants, the doctors, point fingers at each other. And by doing that, they lose the focus to show that they're not responsible. They lose the focus to show that you, the injured patient, may have caused or contributed to your injuries. Once the doctors start pointing fingers at each other, it is an ideal situation for you, the injured patient, because now they will have many, many more things to deal with, and it will be much harder for them to overcome our claims to show that each one of them violated the basic standards of medical care and caused you harm and injury. When they are fighting amongst themselves as to who did what and who contributed what percentage to your injuries, that puts us in the driver's seat. That makes things great for us. Does it happen? Once in a blue moon. And I say once in a blue moon. Meaning, I can tell you in over 33 years of practice, I can count on just one hand the number of times I have actually seen this occur, where a doctor points a finger at a hospital staff, or the hospital staff nurse turns around, points a finger at the doctor. It rarely, rarely happens, because they know that once it does, they've got huge problems, and now we're looking at a case that likely will settle at some point, as opposed to them vigorously fighting it tooth and nail to show not only that there's no wrongdoing, there's no liability, but also that the wrongdoing did not cause or contribute to your injuries. Once the doctors are fighting amongst themselves, now it becomes so much easier for us to go forward and prove our case. And you know what? That's the ideal scenario. That's the ideal situation. But it rarely, rarely happens. Now, during the course of your lawsuit, I have an opportunity to question each one of the doctors whom you have sued. I have a goal. My goal is to try and learn as much as possible about what they did and why. In addition to that, in New York, since these doctors are technically considered medical experts, I am permitted not just to question them as a medical expert, but I can question them as if we are at trial and I am cross-examining them. What does that mean? It means I can ask them leading questions. I don't have to always ask them open-ended questions such as who, what, where, when, how, why. I can now ask them a question such as, Doctor, isn't it true that on January 1st, my client came to you with the following complaint? Isn't it true that on January 1st, the patient told you she had a lump in her left breast? Isn't it true? And so leading questions are a very critical component of doing any type of cross-examination. And I can do that during a deposition together with asking the doctor open-ended questions to learn why he did what he did. Importantly, another job that I have during these depositions is to ask the doctor what we call hypothetical questions. Now, a hypothetical question basically says, Doctor, I want you to assume that the following facts are true. Now, why would I do that? And why would I ever want to do that? I'll tell you why. Because in every lawsuit, especially medical malpractice cases, our client's version of the events tends to be somewhat different than the doctor's version of the events. There are factual disputes. And the doctor believes a certain set of facts, our client believes a certain set of facts. And during my questioning, I'm not going to get the doctor, I'm not going to convince him that our version of the facts are correct. So instead, one of the things I can do when questioning him is to say, Doctor, I want you to assume that the following facts are true. And now I begin to recite segments of what our client has testified to as being the truth, as being the facts as she remembers them. Doctor, I want you to assume that Mrs. Jones has testified that on January 1st she came into your office for a visit. Okay? Well, that's not true. I see in my records that she came in on January 5th. I understand that's what you claim, doctor, but I want you to assume for the moment that what I am telling you is true. If that information is true, would you agree that good medical practice requires that when you see the patient on the very first visit, you do a detailed, thorough history? Well, yes, of course, I would do that for any patient. Great, but you would agree that when you see a patient, a new patient for the very first time, good practice requires that you take a detailed, thorough history. Isn't that true? Yes, it is. Now, doctor, I also want you to assume that on this very first visit, that my client told you she had a complaint of a lump in her left breast. Well, that's absolutely not true. When she came in on January 5th, she did not have a complaint. Doctor, I recognize and I understand that that is your perception of what actually occurred based upon your notes. For the moment, I want you to assume that these facts are true as I explain them to you. And would you agree good medical practice would require that you go ahead and ask follow-up questions about the patient's specific complaint regarding her left breast lump? Isn't that true? And he has to say yes. Now I'm going to continue along this line, building up this sequence of facts. Why do I do that? I do that because I want the doctor to establish for me that if these facts are indeed true, that certain things had to have been done. And why do I want to do that? Because I want later on to be able to show that the doctor's treatment of this patient did not conform to the standard of care, that he deviated or departed from the standard of care. So in addition to learning from the doctor in his own words why he did what he did and go through his actual notes about what happened with this patient, I need to ask him opinion questions. Doctor, do you have an opinion with a reasonable degree of medical certainty that if this patient had come in complaining of a lump in her left breast, whether it would be appropriate to go ahead and do a detailed, thorough history? Oh, yes, it would. Do you agree, doctor, that if this patient did complain of a lump in her left breast, failing to do a detailed, thorough history about that lump in the left breast would be a departure from the standard of care? Yes, it would. He has to answer that question. He won't want to because he's going to know that the moment he says, yes, it's a departure, now we've got a clear factual dispute about what was done, what should have been done, and what he perceives was done. And that is clearly one of my goals when questioning the doctor. So now let's get back to the question I raised at the beginning of this video. Can I get doctor number one to point a finger at doctor number two? Here's what's going to happen. Doctor, you're aware that my client saw doctor number two after leaving your office on January 1st. Are you aware of that? Yes, I am. In fact, doctor number two saw her on January 2nd. Isn't that true? Yes, according to the note that I have, that's true. And doctor, the physician who saw my client, your patient, on January 2nd, sent you a report about that examination. Isn't that true? Yes. And you have a copy of that report in your chart, this patient's chart, correct? Yes. And, in fact, you read that report in preparation for today, didn't you? Yes. And not only that, but you read this report shortly after the doctor sent it to you. Isn't that true? Yes, it is. And doctor, based upon that report, you made certain clinical decisions about what to do next regarding this patient's care and treatment. Isn't that true? Yes, it is. Doctor, would you agree that if you failed to do X, Y, and Z, as a result of reading doctor number two's medical report about his examination on January 2nd, would you agree that that would be a departure from the standard of care? Well, I wouldn't say that. And now the doctor will argue with me, his attorney will argue with me. Doctor, when reading doctor number two's report, do you see anywhere where he made any recommendations? He did not make any recommendations. Would you agree that failing to make any recommendations would be a departure from the standard of care? Objection! His attorney yells out. I will not allow my client, the doctor number one, to go ahead and answer that question. That is an improper question. I direct him not to answer. So what do we have here? We have a legal battle now. We have a legal battle that now his attorney is going to prevent doctor number one from answering opinion questions about what doctor number two did. In that instance, in this hypothetical scenario that I'm presenting to you in this video, doctor number two's attorney would be well within his right to stop his doctor from answering my question. Why? Because it clearly is not appropriate unless unless, and this is the argument I would make, that the two of them are acting in tandem, they're acting as a team to go ahead and treat my client. In that instance, there is law in New York that permits the doctor to go ahead and answer that question. However, during a deposition, there's no judge there. There's no judge to make a ruling and tell us whether or not the doctor can go ahead and answer the question. And in all likelihood, a smart, experienced defense attorney is going to do everything he can to make sure his doctor does not answer that question and point a finger at doctor number one, even though I am technically, in this scenario, technically permitted to get the doctor to answer that question, and technically the doctor has to answer that question. So why do I share this quick information with you? I share it with you because this comes up repeatedly in cases, in medical malpractice cases, where we've sued more than one doctor, and now the question becomes, are they working as a team? Are they working together? Or are they disparate? Are they separate? And one had nothing to do with the other. You know, I realize you're likely watching this video because you wanted to see the beautiful scenery here on the beach. No, I realize you're watching this video because you likely have questions and concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.